Yes. But like, I think that's what we need to do. We are talking, generally speaking, when it comes to finance, and in that situation, when it comes to finance, they are quite flexible. Yeah, so that's, yeah, because they, yes, but when you take the
Okay. Can we get underway? Thank you all for coming out. I know it's an incredibly grotty day. I just want to start first by saying you all will have received an email, or you should have received an email asking you to fill out set evaluations. We know that this is a really terrible time of year to be asking you to do something extra, but please bear in mind that we do really genuinely take on board your feedback. It is enormously helpful for us to know what works well for you, what doesn't. Some things we have control over, some things we don't. We don't have control over when this lecture time is, right? So we don't have control over when our workshop times are, or when, what rooms we are in. But from the feedback we got from students, we were then able a couple of years ago to start instigating the workshop program, which we've found to be enormously successful given the feedback we've received from students since. So please do feed us the good and the bad through your feedback. Obviously keep it away from the personal. It is anonymous, but obviously if you start getting really personal inappropriately, that is something we do refer on, but I'm sure that none of you will do that. But it is something we take on board, and we do think about when we plan for the following year and the year after. So I do appreciate it if you take the time to actually fill it out. And there's a QR code on screen, and that's in your announcements as well, which makes it easier for you to flick through to that. The other thing is that you've also been asked to do one for your tutors. Again, it is something that is really important in terms of retaining the tutorial program, looking to see which tutors have assisted you in your learning, what part of the tutorial program has assisted you in your learning. So if you can fill out that as well. We do tend to get very small amount of feedback, which then becomes not very useful. So again, I know it's a terrible time of year, you're overloaded, you've got lots on, but it is enormously valuable to us. Okay, so turning now to our actual lecture. It was apparent to me in the workshops this week that for many of you, particularly when I asked questions like, so did the person intend to assist or encourage, and those of you in the workshops went, yes, that you hadn't necessarily remembered what it meant to intend to assist someone, or what intention actually meant. So I'm just going to revise quickly the mens rea elements again of section 66(1) to ensure that that is clear in your heads. So when we think about, sorry, I'm too far ahead. When we are thinking about section 66(1), which I've now got on the screen for you, which is a bit more useful, so as I said to you last week, our mens rea requirements are intention, you must intend to assist or encourage, and you must also have knowledge of the essential elements. Okay, so what does that mean? All right, so Arsene has put that into elements which we worked with in the workshops. For those of you that didn't attend the workshops, please do have a look at or listen to the recording. If you didn't attend that, you may also have missed the fact that I've put up on the module for under party liability a sheet which will assist you in working out the aiding and abetting part, so the actus reus part. It is incomplete. The reason for that is because I want you to do some of the work for yourselves. So when we're thinking about mens rea, we're looking at intention to assist or encourage, and we are looking at knowledge of the essential elements, right? Recklessness does not suffice, and you're going to see when we look at section 66(2 what an enormous difference that makes. So, and this is why it's really important that you remember what we taught you in semester 1. Those are your foundational principles of criminal law. What does intention mean? Okay, so when we're thinking about intention, right, you think intention is your purpose or desire to bring that about, or that you knew with a virtual certainty. Okay, so in your first bullet point here, I've inserted the meaning of intention into the requirement, the element, that they must have the purpose or desire of assisting or encouraging the principal offender in committing the offence. Or they know that it is a virtual certainty that with their conduct or their words that they will assist or encourage the principal. Okay, it's not enough for them to think, oh, there might be a risk that I do that. That's recklessness. That doesn't suffice. Okay, even if they think that it might be possible or probable, that's not going to be enough. But remember that the prosecution doesn't need to show that the person intended for the offence to actually be committed. Right, that was our Wentworth case, where the person intended to assist the person buying the Panadine because he wanted to help her, knowing that she was under pressure, even though he didn't actually want the offence of using that codeine to make home-baked heroin. That wasn't a requirement for the prosecution. He only needed to intend to actually to assist her. All right? So that's your intention element. What does it mean to have knowledge of essential matters? What suffices for knowledge? Again, we go back to thinking about our mens rea element of knowledge. What does knowledge mean? Okay, you must accept or assume or have no substantial doubt that the relevant facts exist or are true. Again, recklessness is not enough. Merely thinking that they might amount to a crime or that what the person is doing, that they might be doing something, is not enough. Suspicion is not enough. Right? And the fact that you ought to have known or should have known is also not enough. Okay, suspicion and negligence do not suffice. Now, in Cooper and MOT, Ministry of Transport, this was very much front and centre, and they were looking at quite a lot of the Australian authority in terms of, well, actually, what are we prepared to say in terms of what suffices for knowledge? And then in that instance, he knew that his wife had been drinking, but he didn't know how much. Right? He knew that she wasn't capable of driving because she didn't, let me rephrase that. He knew that she didn't have a driver's licence when she got behind the wheel. And so there were facts there that the court said, well, actually, there were a lot of facts that really should have made you inquire. But if we make you liable there, we're really making you liable for negligence. You ought to have known, or you should have known, you should have inquired. Okay, and they said that that's not enough. All right, and that was confirming negligence is not enough, recklessness is not enough. And they didn't think it sufficed for knowledge in and of itself. And the fact that even if you might say, well, it was willful blindness, it didn't go so far as to say you could infer knowledge from that. Okay, so in Martin, and for those of you that had Ms. Taylor for your sentencing assessment, this should be a case that is familiar to you. In that case, when they looked at whether or not she was aware that she was importing cocaine, there were enough facts there where they said, actually, when we look at the situation in terms of willful blindness, they said, well, we can infer that you actually had knowledge, even though you say you didn't. On the facts that you were aware of, we are going to infer that you did have knowledge. Okay, so that's a credibility issue. They said, yes, you did have actual knowledge. Okay, in Police and Warburton, which is actually a case that was also taken up to the High Court and affirmed. This is a case that's also referred to in your textbook. Again, they looked at what suffices for knowledge in terms of willful blindness. And this woman was aware that her brakes were failing. She'd gone to the mechanic. And the mechanic said, well, I think I've fixed it. She drove the car again and she said they still didn't feel quite right. She had a friend drive her to the airport and she asked the friend to then take the car home, but didn't warn her about the brakes. And the woman on the way home realised that the brakes were feeling a bit soft and a bit dodgy, decided it would be worthwhile continuing to try and drive. And the brakes completely failed, and she ended up running over a 5-year-old, causing really nasty burns to the child. And the person who owned the car was then charged as a secondary party in the fact that she was aware that the brakes had failed and allowed her to drive the car. Now, she said, I didn't have knowledge that she would have an accident. Right? And so the court had to consider, well, what is the level of knowledge she had to have and what were the essential elements that she needed to be aware of? By providing her with the car, knowing that the brakes were dodgy, and she did admit that she had said she might need to go back to the mechanic, they said that that was enough to infer she had actual knowledge that the car was not safe, and by providing her with a car, that was encouraging and assisting her in the commission of the offence. Even though she had no intention of the offence being committed, she intended to do the act or the conduct by providing her with the car with the combined knowledge that the car had dodgy brakes was sufficient. Okay, and that was affirmed by the High Court. Right, so I'm hoping that by giving you just a few cases there that will help you to start seeing the distinction between when we will infer knowledge and what those essential matters are. Right? So the essential matters there were the failure of the brakes, and the conduct was the provision of the car. Okay, even though she didn't intend for the offence to occur. Right? And you'll remember that when we talked about the kimura with the robbery case, that the presence of the weapon was an essential element, and when we looked at that in the workshop, that was something that the person needed to be aware of, needed to be aware of the presence of the weapon for it to be aggravated robbery, and the secondary party needed to be aware that there was going to be a threat of violence. That was an essential element of robbery. Okay? Any questions on that before I proceed on? Right, I'm hoping that that clarifies things a little more. I'm seeing a few nods, that's great, thank you, I appreciate the affirmation. Okay, sorry, so yeah, that's just your kimura case, and so Bainbridge was actually a case where they, in terms of particularised knowledge, they made it very clear. This guy was saying, well, I kind of supplied them with the equipment, but I didn't know which bank they were going to. So this is a reasonably old case. I didn't know which bank that they were going to rob, and the court said, well, that's irrelevant. Right, that wasn't an essential element. And Maxwell was your case where they said, well, you had an awareness of the bracket, right, the general basket. Somebody was, there was going to be a bombing. You didn't need to know the particular elements of that bombing in terms of where it was going to happen, how it was going to happen, what type of bomb it was going to be. It was enough that it was the type of offence that sufficed. Okay, 66.2, you're going to see is a slightly different beast and an even scarier beast, if that's possible. So when we look at section 66.2, this is a means of capturing all parties in what used to be called a joint criminal enterprise or joint enterprise. So where everyone agrees to do something criminal which we now call a common purpose or a common unlawful purpose. And then one person, it was traditionally used where one person then went on and did something that was beyond what had been agreed, right? And everyone then got caught in the same net, was how Section 66(2) always used to be used. So you go into, you form a plan to go in and burgle a house. The idea is that the house should be empty, but in fact the owner of the house didn't go on holiday or whatever it was that he was supposed to be away, and going into the house, and the person comes out, and then one of the parties to the common purpose then assaults the owner of the house. The other person, the other party to the common purpose, does nothing, right? He's gone into the house and committed the burglary. Right, you remember that it is an entry into a building or a ship or all sorts of things, but in this case it's a building that is not authorised and with the intention of carrying out an unlawful offence. So Alan's done nothing other than commit the burglary, but in fact, because he is a party to the common purpose, he is then responsible for anything that happens in pursuance of that common purpose that he knew could well happen. So if he knew that Joe had a propensity for violence, and that actually if they came upon someone that Joe might bash this guy, then he is liable for the assault as well as the burglary. Okay, so that's just the general premise of it. We're going to unpack how all of that works in terms of getting into the detail of it. But I wanted you to just have a little bit of that broad picture idea of how Section 66(2) has traditionally worked before we start getting into the weeds, so to speak. So when you break it down, the way in which this is commonly looked at is you say, you've got to show that you've got a principal and a secondary party, or secondary parties, or even more, one or more principal that form a common intention to prosecute any unlawful purpose, and they have to assist each other therein, right? That assisting each other therein you're going to see is pretty loose and not much is required. And if one of the people, right, usually who you would identify as your principal, then does something in the prosecution of the common purpose, that's the words of the section, which is really, you're just going to find out, is just in pursuance of that common purpose or in the process of carrying out what was agreed, does something, then everyone is liable for all of those offences, provided they did that in pursuance of the common purpose, and it was known by everyone to be a probable consequence of carrying out that common purpose. And obviously we're going to learn a little bit later what probable consequence means, but those are your essential sort of ideas of what you need to establish. Now the rationale for this is essentially the reason why it's a bit looser than Section 66(1) is Andrew Symester characterises this as essentially you've signed up to a goal to do something criminal. You then lose a bit of control over where that goes. Okay, it's a little bit like you've sort of got a snowball that starts at the top of a hill. Right, you start to lose a bit of control as to where that, how that goes down the hill and how big it gets. So once you've actually signed up to your common purpose, the principal is an autonomous agent. You can't control everything that they're going to do in pursuance of it. But because you've committed to the common purpose, which is an unlawful thing, you're already committing to something criminal, and therefore you're already accepting that you are responsible for everything that happens in pursuance of it. So it's worthwhile remembering that rationale when you start to see how the law is applied, because you're going to see that the courts have been very liberal on how we use this. Because it applies to every offence committed by any one of them in that prosecution of the common purpose. And where it starts to become a real issue is when someone dies. Okay, this burglary case that I gave you as an example, what if in bashing the guy who owned the house, right, he then suffers an enormous head injury and he dies as a result? Does that mean that having committed to a burglary, you are now responsible for a homicide? And if you are aware that this person might commit violence with the required mens rea, then yes, you will be. Okay, and you'll remember in the arson case, they also use, for anyone who's read it, I know it's a fairly weighty case, but they use section 66(2) in large part to rope everyone in, including the woman, into that common unlawful purpose. Now, traditionally, section 66(2) was only ever used to capture where you had someone carry out an offence that was beyond what was agreed or intended by the parties to the common unlawful purpose. Okay, so everyone agrees that they're going to do something criminal. And if that is the offence that is carried out, then traditionally we would have only ever used section 66(1) as a means of holding everyone liable. Okay, so you're having to show an intention to encourage or assist or procure or counsel or whatever it might be, and that you had knowledge of the essential elements. Okay, so it was a stricter way of keeping people or roping people into liability, and it was only where someone went on to do something in pursuance of the common unlawful purpose that was seen to be something that might well happen or could well happen. Things get a little bit out of control, a bit unpredictable, in the sense that the person was at home, we didn't expect that. Oh shit, now we're going to have to bash him over the head. Okay, that was only when we used section 66(2). All right, and in 2013, the Court of Appeal looked at this in Boavong and went, is this how we should still be using section 66(2), that we only use it where we have these additional offences that occur beyond what was agreed by the parties? Okay, is that appropriate? Or should we also be capturing in there the original offence that was agreed to? And the Court of Appeal in Boavong said, no, we reaffirm that section 66(2) should only apply to the additional offence carried out, right? The one that the parties didn't agree to, didn't intend, didn't have knowledge of the essential elements. So that is always going to be used for section 66(1), and it's only this additional one that we're going to use section 66(2) for. Supreme Court came along in 2015 in arson and changed all of that. Right, they said section 66(2) is going to apply to every offence committed in the pursuance of the common unlawful purpose, even the offence that is intended by all the parties who joined the unlawful purpose, common unlawful purpose. Now you might think, okay, big deal, right? You might think, well, that's, okay, so what? But when you think about the difference in the mens rea requirements, this becomes a very lower standard to rope everyone in. And if you look at the actual statutory wording, as Julia Tommy points out in her text, it is very awkward to apply it in this way. Right? Now, the court in Arson was saying, well, you know, we don't really like Section 66(2) only being applied to these additional offences, because there might be a situation where someone assists or encourages, but we can't really attribute which individual in the common unlawful purpose did that. So may not be able to use 66(1). Right? We may not actually be able to secure liability. Well, in my thinking is, well, that's tough shit. That's how the criminal law is supposed to apply. Right? No, Arson said, no, we don't like that. No, we're going to make this 66(2) now captures everything, even what you intended to happen, even if we can't show who did what. We can't show that you intended to assist or encourage. It's enough that you knew that that could well happen. Right? If you're reckless when you joined up to this criminal unlawful purpose, this common unlawful purpose to do a criminal thing, if you're reckless as to what might then progress from there, you're going to be caught. Now, you might think, okay, well, that's fair enough because, you know, they've signed up to do something unlawful, but sometimes these things happen in the heat of the moment and people don't necessarily really know what they're signing up for or where the train might go. Right? So when Julia looked at this, she went, okay, well, let's actually work this into, if they're going to apply it in this way, let's see how this works in terms of the statutory wording. So if it was intended to be used in this way, you might say, where two or more persons form a common intention to prosecute any unlawful purpose, okay, two or more people sign up to your common purpose, right, to do an assault, and they assist each other therein, which are the words used in Section 66(2), then if one of the parties commits that assault, the other one is guilty. Okay? Right, that captures what they agreed to, and one of them does something, the other one is also going to be liable. But that's not how Section 66(2) is worded. So if you put the way that the Supreme Court in Arson is trying to make this work, it reads like this: where two or more persons form a common intention to prosecute an assault and to assist each other therein, okay, well, that's okay. Each of them is a party to every assault committed by any one of them in the prosecution of the common purpose of assault. Okay, we're starting to get a little bit wordy here and a little bit odd. If the commission of the assault was known to be a probable consequence of the prosecution of the common purpose of assault. Right? It's just nonsense. I'm hoping that you can all see that. Okay, it's hard to see that that is what Parliament intended, but that's not how the Supreme Court saw it. They said, well, Parliament cannot have contemplated that Section 66(2) was confined to offences other than those intended at the time of entry into the common purpose. All right, so this is a classic example, again, of the court really stretching liability, in the words of a section, to capture criminal liability, cast the net as wide as possible. So they set out the elements at 102 for 66(2). And again, you've got to have a principle, right, and you've got to have this shared understanding or agreement to sign up to your common unlawful purpose. You've got to agree to help each other therein, which, as I said, we'll look at this, but generally that's pretty easy to show. You've then got to prove that the principal committed the offence or offences in pursuance of the common unlawful purpose. So whatever they did was what was agreed, and whatever they did beyond that was in pursuance of it. And either that the offence that was committed was intended by everyone who signed up to the common purpose, or that they knew it was a probable consequence of carrying that out. Okay, and we're going to look at that in a minute, but just try and give you some idea as to what probable consequence means. Something that could well happen. Okay, I'm going to sign up to carry out this burglary, but it could well happen that actually, in the pursuance of that, someone's going to get hurt. That's enough if the person is hurt in the pursuance of the common unlawful purpose of burglary. Okay, so it's foresight of physical and mental elements again, but it's foresight, right? So recklessness is enough. Now, in Burke, which is our most recent case, where they were looking particularly at what is required where you've got a common unlawful purpose of an assault and then somebody ends up killing someone. And they said the key issues that usually arise for Section 66(2) are what is the definition of the common purpose? When thinking about what happens, whether the actions or omissions of the principal party fall within that common unlawful purpose. Okay, were they doing it in pursuance of it? And whether it was known to be a probable consequence of the pursuance of it. Okay, so these are the three things that normally arise as being the most important issues to be considered. So just in highlighting for you, just to make it plain, it should be pretty obvious to you that I don't like this law very much. But you know, the big differences here that arise in terms of your actus reus conduct and words, you know, Section 66(1), you've got to assist, in fact, and or encourage the principal in the commission of the offence, right? So you've actually got to do something, you've got to encourage, you've got to use words that the person hears. But actually for Section 66(2), you don't have to actually provide any assistance or encouragement at all. You've just got to join the common unlawful purpose and say, oh yeah, I'm going to help. Okay, and that agreement to assist everyone therein could be as much as just getting out of a car. Right, everyone gets out of a car together. Okay, well that's sufficient. In terms of mens rea, Section 66(1), you've got to intend to assist or encourage or have knowledge. Whereas under 66(2), you've got to have recklessness. Okay, much lower. Interesting enough, and I'm not going to labour over this, unusually, the loosened requirements for 66(2) actually come from the UK, from English law, which has now actually been overturned or abolished. But the court have said, look, if we are going to change this, we need to actually, Parliament needs to do it. It needs to be a change in the legislation, and until then we are stuck with it. So, looking at our first element, let's just judge. There's a few yawns. Are we better to have a break now before we get into the first element? The first element's actually pretty easy. Do you want to get through that and then we'll have a break? Okay. Right, so much like 66(1), you've got to have a principal offender. Okay, now, again, you can have joint principals, you can have two principals. You all know now, or should know by now, how to make someone liable for an offence. Actus reus, mens rea, etc. Okay? It stands to reason, but I'm going to say it anyway, just in case. Your principal obviously has to be part of the common unlawful purpose. Right? If they're not in there, then section 66.2 doesn't work. Okay, so it's really no different to section 66.1, except you just have this additional thing of showing that your principal is actually part of the common unlawful purpose. I reckon we could get through element 2 as well. Just push you a little bit further. Now, this common unlawful purpose, okay, this is really important. Right? It's a really important thing to be established, and it has to be proven by the prosecution. They are actually the ones who set what the common unlawful purpose is. Okay, so it's a really key part. And you'll see why in a minute, where the courts have said, well, it's actually it's an important thing for the prosecution to think about this from a strategic point of view and how they set the common unlawful purpose. Now, it can be inferred from words or actions prior to, during the offending, and even after the offending. In Queen and Araho, they looked at, they tapped phones and they looked at the communications after the offence had been committed, and they used that as the basis for the common unlawful purpose. Now, the agreement to commit an offence has to be a criminal offence, even though the words of section 66.2 itself allows for it, doesn't make it clear it has to be a criminal offence. Courts have made it clear that it must be a criminal offence. And it's firmed in, most recently in Iti, in the Queen. And it doesn't even need to be constant, right? You can form it and then do something that is not necessarily in the commission or in the pursuance of the common unlawful purpose, and then still come back to it, and that is sufficient. And it can even arise right at the point of the commission of the crime. We see someone, we're going to attack them, stop the car, get out. Now, everyone who gets out of the car is now in agreement with the common unlawful purpose and has agreed to assist each other herein, and off they go, right? So it doesn't necessarily, you're not looking for everybody sitting in a room around a conference table, signing a document, going, okay, right, what are we all going to do today on a criminal scale? Right, number one on the agenda is, okay, it can be really loosely interpreted from just looking at the conduct of what everyone does, not necessarily what is said, and it can be then and there, right? Which is why when you think about the flow-on effect from that is actually quite frightening. I am watching the clock, I promise. You can have more than one common unlawful purpose, and you'll see how that works. Well, you can have a common unlawful purpose and someone who actually does stuff beyond the common unlawful purpose and still continues on with it, and that's the court's saying, well, that's okay. And you don't even have to link the principal party to the secondary party. Right? You don't have to show that these people know each other. Right? Again, you don't have to show that, right, these people got in a room and they had a communication with each other. And as I said earlier, there's no requirement in terms of assistance, encouragement, or doing anything that the secondary party has to do. They just have to sign up to the common unlawful purpose, agree to assist everyone therein, and then so long as they know that it's a probable consequence of the pursuance of it, they are liable for whatever happens, even if they have done nothing. Okay. think defining the common purpose is, you're going to have to wrap your heads around that. So I think we'll take the break there, 10 minutes, and then we'll get into how do you define it and why is that important. Okay. I can see that not everyone is back, but I might just poke my head out the door, actually, in all fairness, because I can see that not everyone is back, and hang on just one moment. All right, I'm going to push on anyway. Okay, so, as I said earlier, who defines the common unlawful purpose, all right? So it is the prosecution. Now, in a case, Supreme Court case of Edmonds, this was a decision where they were looking at the presence of a weapon and what does the secondary party need to know about the presence of a weapon when someone dies, etc., etc. And the court said that actually defining the common unlawful purpose is a really essential part of the prosecution case and talked about the very strategic nature of that, essentially saying when you define the common unlawful purpose as being quite low in terms of what everyone agreed to do, then it's going to be easier to establish the common unlawful purpose, but it's going to be harder to show that what happened if the eventual offences committed were much more serious than what was agreed under the common purpose. It's going to be harder to show they were a probable consequence and that everyone who signed up, or when I say sign up, everyone agreed to the common unlawful purpose knew it was something that could well happen or might well happen, okay, so that it was a probable consequence. All right, so whilst it might be easier to prove your common unlawful purpose, it is going to be harder to ultimately prove your final element of probable consequence where something additional happened or it got much more serious than what was agreed to. Vice versa, if you establish your common unlawful purpose as being too high, right, if you set it at too high a level, it is going to be easier to prove that what did occur, if it's much more serious, was a probable consequence, but you might find it harder to prove the actual common unlawful purpose itself and that all the parties agreed to be part of that unlawful purpose. Right? So setting the actual level of the common unlawful purpose is a really important part for the prosecutor. And you may remember the arson case where they drove past the guy and the two patch members of Black Power and the two young women, and they ended up pulling alongside him. He tried to get in the car. They got out of the car, and then one of the guys picked up I can't remember now quite what it was, I think a bat or something, half bat, wooden bat, and beat him. That the common unlawful purpose set by the prosecution in that case was that they would intimidate and assault people who they believed to be mongrel mob members. Okay, so that's quite a low common unlawful purpose in terms of what was agreed to by everyone, but I suspect that that was easier for them to then show that the two women were a part of that common unlawful purpose, but then it would have been more difficult for them to show the probable consequence, that the death, the serious assault was something that could well happen. Right, so that common unlawful purpose is an important aspect of the prosecution case. And this was very much highlighted by the court in the Edmonds case. And the court in Burke, the Supreme Court more recently, have said that it is really important that there is clarity around what it is. And the offence said by the Crown to be a known probable consequence of the implementation of that common purpose. Okay, so this is really nailing the prosecution down and saying, yeah, you can't be vague about this, although we have seen plenty of cases where it has, which I'll deal with in a minute. But one of the problems that the prosecution had in the Burke case was they were talking about the common purpose being a hiding, whereas in fact the evidence suggested it was a mean hiding, right? And that became an issue in the case because a mean hiding and a hiding meant two different things. A mean hiding was a more serious level of violence than a hiding, right? So the court were very clear with prosecution. You had to be actually quite clear about this. Nevertheless, all right, the courts previously, as was the case in Edmonds, have been prepared to accept prosecution actually giving quite vague ideas of what a common unlawful purpose was. Okay, so in the Edmonds case, these were guys that, and this was very much an example of where the common unlawful purpose was set pretty much right at the last minute. So these guys, it was said as being pursue the group of scaffolders and cause serious violence to somebody in the group. Right? And these guys pretty much stopped, hopped out of the car, and then everyone hopped out of the car was part of the common unlawful purpose. And everyone who then, whether they were involved in the serious violence that was committed, was caught under section 66(2) as a result. Right, so, but they pitched it at quite a high level in terms of serious violence, and they were specific in time in terms of saying it was when the pursuit started, right, but it was, as I say, set at the very last minute. Okay, so then what happened was that when someone was killed in pursuance of that common unlawful purpose, it was much easier for them to show that it was something that everyone knew could well happen. Compare that to the Wahoo case where they said deal out retribution or deliver violence and retaliation. It was considered to be a bit vague. Now, as I said earlier, this third element where we talk about all agree to help each other and participate to achieve the common unlawful goal, it's pretty loose. Okay, and this is generally agreed upon or easily proven just by conduct in the Edmonds case, just all hopping out of the car. All right, you've all agreed to help each other therein, that is enough. Okay, so this idea of reciprocation. So, you're not looking for words of, oh, yeah, mate, yeah, sure, yeah, I'll give you a hand with that, or anything like that. Okay, they're happy to look at conduct and say that that is more than sufficient to show an agreement to assist each other therein. One of the more sticking points as identified in Burke is, so one was establishing your common unlawful purpose, and the other one is, the second one is pursuance of that common unlawful purpose? Okay, what is the offence committed in pursuance of it? Is it the one that's intended? Is it something that happens in addition to what's intended in pursuance of? Right, so establishing what is actually in pursuance of the common unlawful purpose. And the wording of the section talks about prosecution, which can be a bit confusing sometimes, but that is just really, we're talking about pursuance of or in the course of pursuing the common unlawful purpose. Now, I think we've seen a bit of a change in the law here. Giving you a case of Queen and Hubbard, which is, for me, not that long ago, for you, probably well and truly prior to your birth. But in Queen and Hubbard, so these guys agreed that they would carry out a burglary, and so the common unlawful purpose, well, the common intention was the burglary. This was pre-arson, so 66.1 was used for what was intended and 66.2 was used for what happened in addition to what was intended. Now, the guy that Hubbard agreed to carry out the burglary was well known for then setting fire to premises. In fact, Hubbard said to him, "We're not going to set fire to the premises. I don't agree to setting fire to the premises," and made it quite clear. Now, they went in to the premises, business premises, committed the theft, right, so they committed burglary, and there was no question that was done with intention, with, they were co-principals. But then there was this arson, and they charged Hubbard as a secondary party. Right, and he conceded that he had given a passing thought that the principal offender might commit arson. He even went so far as to move his bike as a result, which I have to say I wouldn't have admitted to. But in that instance, they said, well, the offence has been completed, and the arson was not in pursuance of the common unlawful purpose, notwithstanding the fact, right, despite the fact that the principal said he had done it to get rid of any evidence, fingerprints, etc. Right, so he wasn't convicted as a secondary party of arson. Now, I don't think you'd see the same result now. I think he would be caught in as being liable on the basis that he thought it was something that could well happen in pursuance of the common unlawful purpose. In Timoni, this is actually quite a sad case in many ways. So this was an agreement from a number of people that they would carry out a bank robbery. Right? There were 4 of them, and this was a young guy, and it was a bit of a disaster for him from the start. Right, there was an agreement that they would get to the bank early, so there wouldn't be many people there. He couldn't get his car started, so he got to the bank late, and there were more people there than was anticipated. He had a loaded shotgun with him that had been supplied by the principal. And so there were a number of customers in there, and the bank manager at this time was already on a break. So there was no one else that could assist with opening, getting into the area where the main money was. And one of the tellers was actually on the phone, so she alerted the authorities to the fact that they were being robbed. And he was described as being extremely nervous. Now, whilst they had all agreed to carry out this bank robbery, this guy had broken up with his girlfriend. He was having some quite significant emotional problems, and he had in his pocket some suicide notes for his family, for his girlfriend, and once he got into the bank and they offered him money and said, we'll empty the till and everything for you, he didn't accept that money. He asked for them to get in contact with his ex-girlfriend and for her to be brought to the bank, and So it was sort of the idea that he had another agenda, right? That he was actually, this was an attention-seeking thing, and unfortunately, he also took some hostages in the back of the bank, but unfortunately, one of them grabbed for the gun, and the gun went off, and someone was killed. One of the tellers was killed. Right, so everybody was charged with the death, and he was charged with murder, as was the person who supplied the gun. Now, the secondary parties argued that he had his own agenda and that they shouldn't be held liable for the death because what happened was not in pursuance of the common unlawful purpose of carrying out the robbery. And the court said no. The common purpose would include anything ordinarily contemplated as inherent or likely to happen during any robbery, planned robbery, including encountering any resistance from anyone, which might then require taking hostages and involving people in the robbery. So they said that was part of the pursuance of the common unlawful purpose, and therefore they were liable as secondary parties. Right? Even though the death happened half an hour after he had entered the bank and after he had been offered money, they said it was still in pursuance of the common unlawful purpose. So what that suggests, if you look at that approach, that crimes that fall within the scope of parameters of the express or tacit agreement of the parties are covered, even though there might be some departing from the common unlawful purpose, and therefore they're not within the scope, provided the offences that occur are within the probable consequences, then everyone is captured by it. So, Burke, in the Burke decision, the Supreme Court looked at what does the prosecution of the common purpose mean, and actually provided us with a bit more definition on this, and said it's in the course of implementing it, but not necessarily at the same time. Okay, so the scope is wide. And to some extent, they started to suggest a bit of conflation between our final elements, because they talked about if something is not, like there's a close connection between the two, what is in pursuance of the common unlawful purpose, and then what is known to be in a probable consequence of the common unlawful purpose. If it's not committed in the prosecution of the common unlawful purpose, then it's not known, it's unlikely to be known as a probable consequence. And if it's not known as a probable consequence, then it's not likely to be committed in the prosecution of the common purpose either. Now, if you flip that, you run the risk of saying, well, if it's in pursuance of the common unlawful purpose, then it's much more likely to be in a probable consequence. So any conflation of those final two elements, I think, is dangerous, because you're starting to bring in there a level of, it's beyond even recklessness, I would suggest. Now, when we look at element 5, again, this is one of the ones that Burke said was a very important element, one of the key elements that you normally have to consider. So again, remember from arson, section 66(1) says it must be what is intended, or it can include what is intended, rather, sorry. Okay, it can include what is intended in the common unlawful purpose, and what you knew was a probable consequence of the prosecution of the common unlawful purpose. If it's a consequence of the probable consequence of the common unlawful purpose, then it requires foresight of both the physical and mental elements, but foresight is enough. Foresight means that recklessness is enough. You don't have to show knowledge. It's enough that you had a conscious appreciation that that might well happen. Now, there has been some dispute over the years as to whether or not this was in fact a subjective or an objective test. And previous renditions of the Crimes Act prior to 1961, that it was suggested that it was objective, but it's been made very clear now that it is in fact subjective, and this has been reaffirmed in the Bois-Vong case in 2013, and that's not changed. Right, so even though we're seeing a little bit of this conflation between 4 and 5, it is still supposed to be a purely subjective test. Right, did the defendant know that the offence that happened could be something that could well happen in pursuance of the common unlawful purpose? So what does probable mean? Right, so have we actually pinned that down? Yes, we have. Right? The courts have actually been quite consistent on this for once. As far back as 1980 in Quinn and Gush, they said it is something that could well happen rather than one that is more probable than not. In Quinn and Pity, they said it might well happen was sufficient, or a real or substantial risk. And both of these definitions were approved in Arson and Burke by the Supreme Court. Right, so very recently affirmed. In Quinn and Burke, they looked at this quite considerably. And Chief Justice Wynne-Kalman actually thought, for anyone who's interested, at 232 and 233, the judgment, she thought we should be revisiting this. She thought that actually we should be saying that likely was a better option, that was more of a something that was similar to probable, but she couldn't get agreement from the majority on that. But what she was happy to agree with the rest of them was that probable should be used in contrast to merely possible. Possible is not enough, it has to be probable. Now, the secondary party doesn't need to know all the precise details of the offence, that is the same as section 66(1), or even its mode of commission, provided they know that there is a real risk of the type of offence that could be committed. Right, so in the Queen and Whitaker case, when they looked at that, they said it didn't matter that Tanya Whitaker didn't know the way in which the harm was to be inflicted, as long as she knew that there was a real risk of harm. She didn't need to know whether it would be committed by a punch or a kick or a throwing. It was sufficient that she knew that there was a real risk of the type of offence, the level of harm. Again, wilful blindness to the risk of the commission of the offence is enough. Even more so in this case, because you're not having to prove actual knowledge or infer knowledge. From willful blindness, so it's enough that we can just show that the person knew that it was something that could well happen. So if they deliberately didn't turn their mind to it, they shut their eyes to it because they didn't want to inquire, knowing that if they checked, it was something that could well be the case, could be sufficient. So you're working your way down through those layers of mens rea. Okay, we've come down from intent and knowledge, we've come down to recklessness, So much easier to prove. But when does this knowledge have to exist? Again, Arson tidied this up, and they said that your knowledge as to what might be probable is when you join up to the common unlawful purpose. What this suggests is that if you've joined up to the common unlawful purpose even prior to the actual principal offender forming the mens rea, provided you think it's the offence that eventually happens is something that could well happen, even if they haven't formed the mens rea at that time, then potentially you are going to be liable as a secondary party, because looking at those words from Justice Willie Young, right, it seems to imply that it's about when you join the common unlawful purpose. Now, where this raises real problems is withdrawal, which I'm hoping we'll have time to get to. If we don't, I'll do a separate video because I don't want to rush through it for you. Okay, because you have the possibility of, if you've signed up to the common unlawful purpose, to withdraw from it, which is covered in the arson case, but it's very difficult to prove it, and this makes it harder. Now, where you'll see a lot of these cases focus